I want to tell you about her before I tell you about the case, because by the time most people hear about cases like this one, the person at the center of it has already become a number in a file. She was not a number to me. She never was. I have been sitting with this story for 2 years and 4 months. I am telling it now because silence about certain things is not neutrality. It is a choice. And I have made enough choices in this life to know the difference. I have held this story for a long time, not because I was afraid to tell it, because I wanted to tell it right. Subscribe and turn on notifications. That is the only reason I am here today, to tell it right, to the right people. Subscribe before I keep going. The morning the sentence landed, the courtroom went so quiet I could hear the ventilation system in the ceiling. I had been in that room hundreds of times. I had never noticed it before. That silence, the third one, the one after everything had been decided, I am going to come back to it. But first I need to walk you through how we arrived there, because that silence did not arrive without the ones that came before it, and the ones that came before it did not arrive without Margaret. Margaret was 41 years old when she first walked into my courtroom. She had multiple sclerosis. She had been managing it for 11 years with the specific, exhausting competence of someone who has learned to map every room before they enter it. She walked with a cane on her right side, not because she could not walk without it on every day, because some days she could not, and she had stopped being willing to be caught off guard. The first time I saw her, she was making her way to the plaintiff's table, and her attorney was a step behind her, not helping, because Margaret had made clear before they entered that she did not want help navigating. I noticed that. I noticed the way she settled into her chair and then immediately straightened, the way a person does when they are determined not to look like what they feel. There are people you watch because they are dangerous. There are people you watch because they are frightened. And then there are people you watch because you understand without being told that they have been holding something together through sheer will for a very long time, and the effort costs them more than is visible unless you are paying the right kind of attention. I paid that attention to Margaret. The defendant was a specialist physician, Dr. Raymond Ellard, 53 years old, neurology practice, private, 11 years in operation, 3 satellite offices. He entered the courtroom the way certain men enter rooms, slightly ahead of the moment, as if the room were something happening to him rather than a place he had chosen to come to. He checked his phone once before proceedings began, which is not permitted. When I addressed that, he smiled very briefly, not at me, at the table, in a way that told me he had decided the remark was a formality. There was one moment near the end of the second day when his composure slipped by about 2 degrees. He was watching Margaret speak, and for just a moment his face changed, not into remorse, into something more complicated, recognition maybe, the beginning of it. I have thought about that moment since, not because it changed anything, because it arrived too late to mean what it might have meant. That is what made it worse, not better. Subscribe, not for me, for the reason I am telling this. Some stories need more people to carry them than were in the room when they happened. Subscribe and help me carry this one. Let me tell you what happened to Margaret on September 14th, 2022. She had been experiencing new symptoms for about 6 weeks. Numbness in her left hand, vision disturbances, fatigue beyond what she was used to, and she was used to significant fatigue. Her primary care physician referred her to a neurologist. The first practice had a 4-month wait. She called 3 others. Same answer, roughly. When she reached Dr. Ellard's office, there was an appointment available in 8 days. She took it. She drove 40 minutes to the office, arrived at 9:50 for a tentative appointment, checked in, provided her insurance, waited 31 minutes. Then a staff member came to the waiting room and said quietly that there was an issue. Margaret was brought to a side office. The staff member explained that Dr. Ellard's practice did not accept her insurance plan. This was not something Margaret had been told when she called. It was not on the practice's public-facing information at the time. When Margaret asked about her options, she was told she could be seen that day if she paid the full consultation fee up front, $850, cash or credit card. Margaret did not have $850 available at that moment. She asked whether a payment plan was possible. She asked whether she could be seen and billed. She was told no. She asked to speak with Dr. Ellard directly. Dr. Ellard came to the doorway of that office. He did not come inside. He stood in the doorway and said, "I understand your situation, but I run a business. I cannot provide services without payment. That is not a policy I created personally. That is just how private practice works." Margaret gathered her things and drove 40 minutes home. Her left hand was numb during the drive. She managed it. I want to ask you to subscribe before I go further, and I want you to know that I do not ask lightly. What comes next in this story is the part that cost me the most to say out loud. Subscribe. Stay with it. The complaint was filed 11 days later. It entered the civil system and came to my courtroom 4 months after that. During discovery, both sides exchanged documents and records. That process produced something important. It produced a staff email sent by Dr. Ellard to his office manager 8 months before Margaret's appointment. In that email, Dr. Ellard reviewed which insurance plans the practice was accepting. He identified 3 specific plans, Margaret's was one of them, and wrote, "Let's quietly phase these out. We do not need to make announcements. Just stop accepting new patients on these plans." The word "quietly" was underlined in the original. I do not know if he meant to underline it. I know that he did. The legal claim with weight was this: a patient with a documented disability had been turned away through a procedure specifically designed not to be visible. She was not told on the phone. She was not told at the front desk. She was told after 31 minutes of waiting in a side office, when leaving was a different kind of decision than not having come at all. There is a term in civil disability rights law called constructive denial of access. It does not require a locked door or a sign. It requires only that the system be arranged in a way that produces exclusion as a consistent result, whether or not that was the stated intention. I have explained this to myself more times than I needed to during this case. My role is to hear what the law can address. I know that the law can address a portion of what actually happens to people. Only a portion. I have accepted that fact. I am not at peace with it in any other sense. There were 3 moments in that courtroom where the room went completely quiet. Not the quiet between sentences, the kind that settles when something true has just entered the room and nobody knows what to do with it yet. I am going to tell you about all 3. Subscribe before I go further. I have more to tell. And the more I tell, the more it matters that someone is listening. Subscribe and turn on notifications. Then let me continue. Silence 1 arrived on the second day of proceedings. Margaret was on the stand giving testimony about the 40-minute drive home. Her attorney asked her what she was thinking about during that drive. Margaret was quiet for a moment. Then she said, "I was thinking about whether I had said the right things, whether I had explained myself well enough, whether if I had been calmer or clearer. I kept thinking that maybe I had done something wrong that I was not aware of." The room stopped. I know the difference between a room that is quiet because nothing is happening and a room that is quiet because everyone in it has just heard something they recognized. This was the second kind. It lasted 8 seconds. Dr. Ellard's attorney broke it by writing something on his legal pad. The sound of the pen was very loud. What I understood after silence 1 that I had not understood before, it was the nature of the deeper harm. The medical harm was documentable. The other harm, the kind where a person drives 40 minutes home, reviewing her own behavior to find the flaw that made her deserve what happened, that harm has no line on any form. But it was in the room, and I could not proceed as if I had not heard it. I want to set a memory next to this case. I am going to ask you to hold both at the same time. When I was 32 years old, my mother went alone to see a specialist about a pain in her hip that turned out to be serious. She came home and sat at the kitchen table, and I asked how it went. She said it went fine. She said the doctor was very busy but had been kind. I found out later from my aunt that she had waited 2 hours and been seen for less than 11 minutes. She had not mentioned the 2 hours. She had not mentioned the 11 minutes. She said he was kind because he had smiled at her once when he came in, and she had decided to give him that. She spent the drive home, I think, reviewing whether she had asked the right questions. I have never said that in a professional context before. I am saying it now. The evidence around Silence 1 included phone records showing no disclosure of insurance status when Margaret called, her appointment confirmation with no financial pre-authorization language, her medical record showing symptom progression during the weeks it took to find another specialist, and the 4 weeks of delayed diagnosis that followed. Her treating neurologist later testified that one of those weeks represented a window for early intervention that was narrowed by the delay. I wrote that down too. If you are still here at this point in the story, you already understand something important about why I am telling it. Subscribe. This is what I do now. I tell the cases that stayed with me. Subscribe and you will hear the rest of them. The defense was thorough. Dr. Ellard's attorney argued that the practice had a legal right to set its own payment terms. That is true. He argued that the failure to disclose insurance status before the appointment was an administrative error, not policy. That was contradicted directly by the email. He argued that Margaret had other options available and chose not to pursue them before filing. That argument required a reading of the word options that I could not accept. There was one moment where the defense came genuinely close. The office manager testified that the phase-out had been handled incorrectly, that the website should have been updated, that no one intended to harm anyone. I sat with that. Intent is a real legal consideration. I sat with it for the better part of an afternoon. What ended the pause was one word. The email said, quietly, intent to harm and intent to conceal are different legal considerations, but the result of the quiet phase-out was that a woman with a documented disability drove 40 minutes, waited 31 minutes, and was told in a side office, not at the door, not on the phone, but in a side office after the wait of arrival had already settled, that she could not be seen. Dr. Ellard testified. He was measured. He said at one point something I wrote down and looked at for a long time before turning the page. He said, I have treated hundreds of patients with multiple sclerosis over the course of my career. I have a great deal of respect for the challenges they face. He said it as a defense. I believe he may have even meant it. I looked at what it meant that you could hold both things at once, that respect and that side office, and find no contradiction between them. That is what I looked at. Then I turned the page. Silence. 2 arrived after Dr. Ellard's testimony ended. His attorney said no further questions. The defense rested. The room went quiet in a way that was entirely different from Silence 1. Silence 1 was recognition. This was arrival. The room had been traveling toward a point and had now reached it and needed a moment before anyone decided what to do next. Margaret had her legal pad open. She was not writing. She was looking at the table. The second silence lasted longer than the first. I counted to 12 before anyone moved. It was Dr. Ellard, who reached for his water glass and then set it down without drinking. What the room understood in Silence 2 was that the shape of the case was now complete. Every argument had been made. Every document entered. What remained was the gap. The same gap I had been looking at since the email, since Silence 1, since Margaret's 8 seconds on the stand, the gap between what Dr. Ellard believed about himself and what September 14, 2022 had actually been. Subscribe if you are willing to carry this story past this video. That is what subscribing means to me, not a number, a person who will remember this. Subscribe. I had made this decision carefully. I had made it knowing that careful decisions and right decisions are not always the same thing, and believing that in this case they were. I looked at Margaret before I began. Her hands were flat on the table. I am ordering you to pay $125,000 in compensatory damages directed entirely to the state's Neurological Care Access Fund, a fund established specifically to cover specialty consultations for patients whose insurance plans are excluded by private practices. The connection is not symbolic, it is direct. You built a system that turned Margaret away. That fund exists to receive people that system turns away. You will now fund it. I am also ordering suspension of your license to operate satellite offices for a period of 18 months. During that period, you will see patients exclusively at your primary practice location under state medical board oversight, with full written disclosure of all accepted insurance plans posted at the front entrance, visible before check-in, reviewed quarterly. This is not a punishment for running a practice. It is a requirement that the practice you run not use geography as a second barrier after insurance. Within 90 days, you will complete 200 hours of service with a non-profit organization providing neurological care navigation to patients on low reimbursement plans. Not administrative service, direct patient-facing service. You will sit across from people who are trying to get the kind of care your practice declined to provide. You will document what you observe and submit a written report to this court. That report will be made part of the public record. You will provide Margaret directly and at no cost 1 year of specialist neurology consultations at your primary practice with scheduling priority. She has been managing a progressive condition. The delay your practice produced did not pause that condition. You will not be permitted to profit from that delay. And finally, you will provide a written public statement submitted to the State Medical Association's journal and read into the record of this court, acknowledging specifically that your practice's insurance phase-out procedure resulted in the denial of timely specialist care to a patient with a documented disability, and that the procedure was designed not to be visible to the patients it affected. No third-party language, no passive voice, your name on it. I delivered that sentencing without triumph. I was not satisfied. I was speaking from a place I had arrived at through grief and from which I could now speak with clarity, and I knew the distance between those two things and tried to honor it. Then silence 3, the ventilation system in the ceiling. Margaret's hands still flat on the table. Dr. Ellard looking at the surface in front of him. His attorney's pen motionless. Nobody in the gallery moving. 10, maybe 11 seconds. Then Margaret's attorney placed a hand briefly on her shoulder and removed it. Margaret did not look up. She nodded very slightly, the way a person nods when they have been waiting to hear something confirmed that they already knew. And the confirmation is not relief exactly, but it is something. I remained on the bench as the room cleared. Margaret was one of the last to leave. Near the door, she stopped and said something to her attorney in a voice too low for me to hear. Her attorney nodded twice. Then Margaret went through the door. I stood up. The room was almost empty. The fluorescent light above the witness stand was flickering in a way it had never flickered before, or maybe I had never noticed. I noticed it then. Dr. Ellard appealed. The appellate court upheld the compensatory damages in full and upheld the license supervision requirement. They narrowed the scope of the public statement requirement slightly. The venue remained the same, but certain specific language was adjusted. 7 months. Then it was settled. My honest response to the appeal was this: I expected it, not the outcome, the attempt. Appeals are how people manage the gap between what a ruling says and what they are willing to accept about themselves. I have watched enough of them to understand that. On March 6, 2024, I received a letter from an attorney I know who does disability advocacy work. She told me that Margaret had agreed to speak to a patient advocacy group about her case. She stood at a podium in front of 38 people and described what happened to her on September 14, 2022. She did not read from notes. She spoke for 14 minutes. I put the letter down and sat with it. There are other people I want to speak for, other cases where someone needed a voice in that room and received procedure instead. Subscribe and I will tell you those stories when I'm ready to tell them. This was the first one I was ready for. I do not know whether the damage of reviewing your own behavior on a 40-minute drive, looking for the flaw that earned you a side office, I do not know whether what I ordered was enough to address that. I have thought about it for 2 years and 4 months. I keep thinking about it. What I know is that the case is the reason I keep asking the question. And that is a reasonable question to keep asking. Grief and clarity are not opposites. I have found that one tends to produce the other if you are willing to sit with the grief long enough and look at it with precision. That is what I have tried to do with this case. To anyone who has ever sat in a side office and been told that the terms of your care require something you do not currently have, I know what I saw in Margaret's face during that trial. It was not anger. It was a kind of profound, practiced unsurprise. The look of someone who has been managing for a very long time, who checked in, answered every question, waited 31 minutes, and then sat in a chair while a stranger explained gently that she could not be accommodated today. I am speaking directly to the feeling underneath that look. You did not do anything wrong that you were not aware of. The room was arranged the way it was before you arrived. You are not the reason for the arrangement. To anyone in a position similar to Dr. Ellard's, running a practice, deciding which plans to accept, writing emails with certain words underlined, the question I wanted to ask from the bench but could not ask from the bench was this. When you wrote the word quietly, what did you understand about why it needed to be quiet? I am asking it now, not rhetorically. Somewhere in the answer to that question is the only place real accountability can begin. The question belongs to you now. Thank you for staying with this. I mean it in the specific way you mean something when it costs you something to say. Subscribe if you have not yet. You already know why you are still here. Tell me in the comments what stayed with you. I read them. The people who find their way to this room tend to be people who are paying the right kind of attention. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay.